My name is Dylan Finlay. I'm a criminal defense lawyer with Strategic Criminal Defense in Toronto. One of the most common questions I get is, how can I be charged? There's no evidence, or there's no proof. This question is particularly common in domestic cases, where the accused and alleged victim are domestic partners, like husband and wife. This can include assault or sexual assault charges. In these cases, it is common for only two people to know what really happened. That's why we call these cases he said, she said cases. So, there's a lot going on with this question. Let's break it down. First, proof. What is proof? Proof is a standard that's determined by a judge. In criminal cases, that standard is beyond a reasonable doubt. A judge must determine if, based on all the evidence, it's been proven beyond a reasonable doubt that a particular crime was committed. That brings us to evidence. Evidence can come in many forms. It can include physical evidence, like a video, or an object, like a weapon. Evidence can also include testimonial or viva voce evidence. Viva voce is a Latin word that means by word of mouth. Practically, what that means is someone comes to trial, swears an oath to tell the truth, and then testifies that they saw something happen. We call that person a witness. Witnesses can and do include the alleged victim of the crime. We call that person a complainant. It is common for the complainant to attend court and testify that a particular crime was committed against them. That said, evidence is not determinative. A judge must determine if, based on all the evidence, it's been proven that a particular crime has been committed beyond a reasonable doubt. But how does a judge decide if what a particular witness has said is true? There are a number of tools judges can apply to determine this. Overall, judges assess a witness's credibility and reliability. Credibility is an assessment of how truthful someone is. Reliability is an assessment of how accurate a witness's testimony is. A witness may be honestly trying to tell the truth, but their memory may be mistaken or influenced by some external factor, like impairment by alcohol. To assess credibility and reliability, a judge may consider what a witness said at trial and compare that to what they said on earlier occasions, including what they said to the police. Judges may also compare what a witness said at trial with other physical evidence, including videos. When the police investigate a crime, they collect witness statements. Based on these statements, the police form grounds to believe a crime was committed and charge you. Technically, those witness statements are not evidence. Rather, they're a preview of what we can expect those witnesses to say at trial. When we prepare for trial, we carefully examine everything a witness has said to the police and anyone else, and compare that with any physical evidence. We also compare that to your recollection of what happened, and based on that, we carefully assess whether we think it's in your interest for you to testify and provide your own viva voce evidence. Based on all the anticipated evidence, we carefully make a trial strategy to challenge the evidence against you. If you find yourself charged in a he said, she said case, it's important that you retain someone with trial experience to challenge the anticipated evidence against you.